Section 494 of Indian Penal Code says about bigamy. Any person who has performed, who got married and his first marriage is subsisting, his first wife is still living, but he contracts another marriage, second marriage, even before his first marriage was not dissolved, then it is a crime under 494 IPC. It attracts 7 years imprisonment. But there are again conditions. The person, that is the first wife, who goes to court and complains that her husband contracted second marriage even before her marriage with her husband, first husband, is not dissolved, she has to prove before the court that there are two marriages, first marriage with her and second marriage with XYZ. Unless it is established that there are two valid marriages, there are two marriages performed, first with the complainant and the other with the new incumbent. Again, to prove the second marriage, there must be Datta Homa and Saptapadi in both the marriages according to customs. Suppose there are two marriages, a man marrying two marriages. In both the marriages, he has been subjected to Datta Homa and Saptapadi. There are video clippings of first marriage and video marriages of second marriage. First wife is still living, and first marriage is not dissolved by any court. That is also important. No court has dissolved the first marriage. It is established beyond all reasonable doubts that ex-husband got marriages. There are two wives. First marriage is not dissolved. Then it is said that offence of 494 is made out, and 7 years imprisonment if such a case is proved. Now, we will come to the example of one lady with whom her husband got married amidst 150 people, inclusive of relatives, friends, well-wishers. In a big grand way, in a big way, marriage was performed, all rituals performed. There was Datta Homa, Saptapadi, and electronic evidence was also available. She comes to know that her husband got married to a lady working in a Xerox shop. Then she goes to police station, lodges a complaint against her husband. Now her husband also filed another case saying that her husband's first wife, another wife, second wife lodges a complaint saying that in fact her marriage with this husband was first marriage, and the lady who complained was the second wife. So this way disputes between two wives, one claiming to be the first, other claiming to be the first. Then in these two wives, who is real, who is first wife, who is the second wife? So it is a question of fact triable by the magistrate, and these two wives are bounded by the duty of proving their marriage according to the Hindu law. Both have to prove that there was no second marriage. Both have to prove that her husband contracted second marriage and her marriage with her husband was first marriage. This is the issue. So in one case, a court of Sweden granted a decree, and this wife suppressed that material fact, and she approaches Hyderabad court and lodges a private complaint against her husband saying that husband contracted second marriage, so it was a bigamy. Then in the cross examination, the issue of Sweden court granting divorce comes out. So in such case there cannot be a bigamy. Bigamy means there shall not be any dissolution of first marriage. and first wife must be living, first marriage must be also subsisting. If these two aspects are seen very carefully, one can either get the punishment or come out of the crime without there being any punishment. This is what is bigamy.